Hey folks, welcome to the Law of Self-Defense Show. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you very much. Welcome back to our ongoing readings of seminal U.S. Supreme Court decisions on the Second Amendment. This one involves my reading of the majority opinion in McDonald v. Chicago, the second of the three major seminal Second Amendment positions. The first was Heller. I've already read that for you. Now we're doing McDonald, and this will be followed, of course, by Bruen. Now, this majority of opinion in favor of the Second Amendment in McDonald was written by Justice Samuel Alito. There's a concurrence by Justice Antonin Scalia, who wrote Heller, and there's a separate concurrence by Justice Thomas Clarence, who, of course, would go on to write Bruen. Also supporting the majority decision was Chief Justice Roberts and Justice Kennedy. Now, I'm only reading here the majority of opinion by Alito, not the concurrences by Thomas and by Scalia. I'll have to get to those at a later date. Also, there were two dissents. One was written by Justice Stevens and one by Justice Breyer. Those were supported. Breyer's was supported by Ginsburg and Sotomayor, of course. So it was ultimately a 5-4 decision. I'm not reading the dissents here either. I don't know if I'll ever will. Reading anything that Sotomayor agrees with is very painful, perhaps someday in the future. But what you'll get here is the reading of Justice Alito's majority opinion in McDonald. This will be in two parts. I'm reading here part 1 of 2. Next will be part 2 of 2. But let's go ahead and get started with this reading of the majority opinion in McDonald v. Chicago, reaffirming that the Second Amendment right, recognized in Heller, guaranteeing a right to keep and bear arms for purposes of self-defense, applies not just to the federal government, but also to the states. And this is part 1 of 2 of that reading. Here we go. Hey folks, if you like this Law of Self-Defense content, and I know you do, that's why you're here, you may as well consider picking up a free copy of our best-selling book, The Law of Self-Defense Principles. It's a real physical book. It's not just a PDF download. You can check it out on Amazon, where it's 5-star rated, over 1,400 reviews, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. We only ask that you cover the cost of shipping the book to you. The book itself is free. You can get this book, learn more about it at lawofselfdefense.com/free book. Hey folks, welcome to the Law of Self-Defense Show. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you very much. Thank you very much. Today's show continues my reading of the 3 seminal Second Amendment decisions that have come out of the U.S. Supreme Court since 2008. We previously read D.C. v. Heller. Today, I begin the reading of McDonald v. Chicago. This was a decision handed down by the U.S. Supreme Court in 2010. It was a 5-4 decision, just as Heller was. Justice Samuel Alito wrote the majority opinion, and it was supported by Chief Justice Roberts, Justice Souter, Justice Kennedy, and Justice Thomas. In dissent were the 4 justices Stevens, Breyer, Ginsburg, and, of course, Sotomayor. So this decision, again, is favorable to the Second Amendment, very much so. It begins with an overview of the case and the decision, and then we'll jump right into the majority decision. 2 years ago, in District of Columbia v. Heller, this court held that the Second Amendment protects the right to keep and bear arms for the purpose of self-defense and struck down a District of Columbia law that banned the possession of handguns in the home. Chicago, hereinafter city, and the village of Oak Park, a Chicago suburb, have laws effectively banning handgun possession by almost all private citizens. After Heller, petitioners filed this federal suit against the city, which was consolidated with 2 related actions, alleging that the city's handgun ban has left them vulnerable to criminals. They sought a declaration that the ban and several related city ordinances violate the Second and 14th Amendments. Rejecting petitioners' argument that the ordinances are unconstitutional, the court noted that the Seventh Circuit previously had upheld the constitutionality of a handgun ban. that Heller had explicitly refrained from opining on whether the Second Amendment applied to the states, and that the court had a duty to follow established circuit precedent. The Seventh Circuit affirmed, relying on three 19th century cases, United States v. Cruikshank, Presser v. Illinois, and Miller v. Texas, which were decided in the wake of this court's interpretation of the 14th Amendment's privileges or immunities clause in the slaughterhouse cases. Held, the judgment is reversed and the case is remanded. Justice Alito delivered the opinion of the court with respect to Parts 1, 2A, 2B, 2D, 3A, and 3B, concluding that the 14th Amendment incorporates the Second Amendment right, recognized in Heller, to keep and bear arms for the purpose of self-defense. Petitioners based their case on two submissions. Primarily, they argue that the right to keep and bear arms is protected by the Privileges or Immunities Clause of the 14th Amendment, and that the slaughterhouse case's narrow interpretation of the clause should now be rejected. As a secondary argument, they contend that the 14th Amendment's Due Process Clause incorporates the Second Amendment right. Chicago and Oak Park, municipal respondents, maintain that a right set out in the Bill of Rights applies to the states only when it is an indispensable attribute of any civilized legal system. If it is possible to imagine a civilized country that does not recognize the right, municipal respondents assert, that right is not protected by due process. And since there are civilized countries that ban or strictly regulate the private possession of handguns, they maintain that due process does not preclude such measures. The Bill of Rights, including the Second Amendment, originally applied only to the federal government, not to the states. But constitutional amendments adopted in the Civil War's aftermath fundamentally altered the federal system. 4 years after the adoption of the 14th Amendment, this court held in the slaughterhouse cases that the Privileges or Immunities Clause protects only those rights which owe their existence to the federal government, its national character, its constitution, or its laws, and that the fundamental rights predating the creation of the federal government were not protected by the clause. Under this narrow reading, the court held that the Privileges or Immunities Clause protects only very limited rights. Subsequently, the court held that the Second Amendment applies only to the federal government in Cruikshank, Presser, and Miller, the decisions on which the Seventh Circuit relied in this case. Whether the Second Amendment right to keep and bear arms applies to the states is considered in light of the court's precedents applying the Bill of Rights protections to the states. In the late 19th century, the court began to hold that the Due Process Clause prohibits the states from infringing Bill of Rights protections. 5 features of the approach taken during the ensuing era are noted. First, the court viewed the due process question as entirely separate from the question whether a right was a privilege or immunity of national citizenship. Second, the court explained that the only rights due process protected against state infringement were those of such a nature that they are included in the conception of due process of law. Third, some cases during this era can be seen as having asked if a civilized system could be imagined that would not accord the particular protection asserted therein. Fourth, the court did not hesitate to hold that a Bill of Rights guarantee failed to meet the test for due process clause protection, finding, for example, that freedom of speech and press qualified. But the grand jury indictment requirement did not. Finally, even when such a right was held to fall within the conception of due process, the protection or remedies afforded against state infringement sometimes differed from those provided against abridgment by the federal government. Justice Black championed the alternative theory that Section 1 of the 14th Amendment totally incorporated all of the Bill of Rights provisions, but the court has never embraced that theory. The court eventually moved in the direction advocated by Justice Black by adopting a theory of selective incorporation, by which the Due Process Clause incorporates particular rights contained in the first 8 amendments. These decisions abandoned 3 of the characteristics of the earlier period: The court clarified that the governing standard is whether a particular Bill of Rights protection is fundamental to our nation's particular scheme of ordered liberty and system of justice. The court eventually held that almost all of the Bill of Rights guarantees met the requirements for protection under the Due Process Clause. The court also held that Bill of Rights protections must all be enforced against the states under the 14th Amendment according to the same standards that protect those personal rights against federal encroachment. Under this approach, the court overruled earlier decisions holding that particular Bill of Rights guarantees or remedies did not apply to the states. The 14th Amendment makes the Second Amendment right to keep and bear arms fully applicable to the states. The court must decide whether that right is fundamental to the nation's scheme of ordered liberty, or, as the court has said in a related context, whether it is deeply rooted in this nation's history and tradition. Heller points unmistakably to the answer. Self-defense is a basic right recognized by many legal systems from ancient times to the present, and the Heller court held that individual self-defense is the central component of the Second Amendment right. Explaining that the need for defense of self, family, and property is most acute in the home, the court found that this right applies to handguns because they are the most preferred firearm in the nation to keep and use for protection of one's home and family. It thus concluded that citizens must be permitted to use handguns for their core lawful purpose of self-defense. Heller also clarifies that this right is deeply rooted in this nation's history and traditions. Heller explored the right's origins in English law and noted the esteem with which the right was regarded during the colonial era and at the time of the ratification of the Bill of Rights. This is powerful evidence that the right was regarded as fundamental in the sense relevant here. That understanding persisted in the years immediately following the Bill of Rights ratification and is confirmed by the state constitutions of that era, which protected the right to keep and bear arms. A survey of the contemporaneous history also demonstrates clearly that the 14th Amendment's framers and ratifiers counted the right to keep and bear arms among those fundamental rights necessary to the nation's system of ordered liberty. By the 1850s, the fear that the national government would disarm the universal militia had largely faded, but the right to keep and bear arms was highly valued for self-defense. Abolitionist authors wrote in support of the right, and attempts to disarm Free Soilers in bloody Kansas met with outrage that the constitutional right to keep and bear arms had been taken from the people. After the Civil War, the Southern states engaged in systematic efforts to disarm and injure African Americans. These injustices prompted the 39th Congress to pass the Freedmen's Bureau Act of 1866 and the Civil Rights Act of 1866 to protect the right to keep and bear arms. Congress, however, ultimately deemed these legislative remedies insufficient and approved the 14th Amendment. Today, it is generally accepted that the amendment was understood to provide a constitutional basis for protecting the rights set out in the Civil Rights Act. In congressional debates on the proposed amendment, its legislative proponents in the 39th Congress refer to the right to keep and bear arms as a fundamental right deserving of protection. Evidence from the period immediately following the amendment's ratification confirms that that right was considered fundamental. Despite all this evidence, municipal respondents argue that members of Congress overwhelmingly viewed Section 1 of the 14th Amendment as purely an anti-discrimination rule. But while Section 1 does contain an anti-discrimination rule, the Equal Protection Clause, it can hardly be said that the section does no more than prohibit discrimination. If what municipal respondents mean is that the Second Amendment should be singled out for special and specially unfavorable treatment, the court rejects the suggestion. The right to keep and bear arms must be regarded as a substantive guarantee, not a prohibition that could be ignored so long as the states legislated in an even-handed manner. Justice Alito, joined by the Chief Justice, Justice Scalia, and Justice Kennedy, concluded in Parts 2C, 4, and 5 that the 14th Amendment's Due Process Clause incorporates the Second Amendment right recognized in Heller. Petitioners argue that the Second Amendment right is one of the privileges or immunities of citizens of the United States. There is no need to reconsider the court's interpretation of the Privileges or Immunities Clause in the slaughterhouse cases because, for many decades, the court has analyzed the question whether particular rights are protected against state infringement under the 14th Amendment's Due Process Clause. Municipal respondents' remaining arguments are rejected because they are at war with Heller's central holding. In effect, they ask the court to hold the right to keep and bear arms as subject to a different body of rules for incorporation than the other Bill of Rights guarantees. The dissent's objections are addressed and rejected. Justice Thomas agreed that the 14th Amendment makes the Second Amendment right to keep and bear arms that was recognized in District of Columbia v. Heller fully applicable to the states. However, he asserted, there is a path to this conclusion that is more straightforward and more faithful to the Second Amendment's text and history. The court is correct in describing the Second Amendment right as fundamental to the American scheme of ordered liberty and deeply rooted in this nation's history and traditions. But the 14th Amendment's Due Process Clause, which speaks only to process, cannot impose the type of substantive restraint on state legislation that the court asserts. Rather, the right to keep and bear arms is enforceable against the states because it is a privilege of American citizenship recognized by Section 1 of the 14th Amendment, which provides, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. In interpreting this language, it is important to recall that constitutional provisions are written to be understood by the voters. The objective of this inquiry is to discern what ordinary citizens at the time of the 14th Amendment's ratification would have understood that amendment's Privileges or Immunities Clause to mean. A survey of contemporary legal authorities plainly shows that at the time, the ratifying public understood the clause to protect constitutionally enumerated rights, including the right to keep and bear arms. Justice Alito announced the judgment of the court and delivered the opinion of the court with respect to Parts 1, 2A, 2B, 2D, 3A, and 3B, in which Roberts, Chief Justice, and Scalia, Kennedy, and Thomas, Justices, joined, and an opinion with respect to Parts 2C, 4, and 5, in which Roberts, Chief Justice, and Scalia and Kennedy, Justices, join. Justice Scalia filed a concurring opinion. Justice Thomas filed an opinion concurring in part and concurring in the judgment. Justice Stevens filed a dissenting opinion. Justice Breyer filed a dissenting opinion in which Justices Ginsburg and Sotomayor joined. Now, the formal reading of the majority opinion in Otis McDonald, Petitioners v. City of Chicago, Illinois. This decision was handed down on June 28, 2010. Justice Alito announced the judgment of the court and delivered the opinion of the court with respect to Parts 1, 2A, 2B, 2D, 11A, and 11B, in which the Chief Justice, Justice Scalia, Justice Kennedy, and Justice Thomas join, and an opinion with respect to Parts 2C, 4, and 5, in which the Chief Justice, Justice Scalia, and Justice Kennedy join. 2 years ago, in District of Columbia v. Heller, we held that the Second Amendment protects the right to keep and bear arms for the purpose of self-defense, and we struck down a District of Columbia law that banned the possession of handguns in the home. The City of Chicago, and the Village of Oak Park, a Chicago suburb, have laws that are similar to the District of Columbia's, but Chicago and Oak Park argue that their laws are constitutional because the Second Amendment has no application to the states. We have previously held that most of the provisions of the Bill of Rights apply with full force to both the federal government and the states. Applying the standard that is well established in our case law, we hold that the Second Amendment right is fully applicable to the states. Part 1. Otis McDonald, Adam Orlov, Colleen Lawson, and David Lawson, Chicago petitioners, are Chicago residents who would like to keep handguns in their homes for self-defense, but are prohibited from doing so by Chicago's firearms laws. A city ordinance provides that no person shall possess any firearm unless such person is the holder of a valid registration certificate for such firearm. The code then prohibits registration of most handguns, thus effectively banning handgun possession by almost all private citizens who reside in the city. Like Chicago, Oak Park makes it unlawful for any person to possess any firearm, a term that includes pistols, revolvers, guns, and small arms, commonly known as handguns. Chicago enacted its handgun ban to protect its residents from the loss of property and injury or death from firearms. The Chicago petitioners and their amici, however, argue that the handgun ban has left them vulnerable to criminals. Chicago Police Department statistics, we are told, reveal that the city's handgun murder rate has actually increased since the ban was enacted, and that Chicago residents now face one of the highest murder rates in the country, and rates of other violent crimes that exceed the average in comparable cities. Several of the Chicago petitioners have been the targets of threats and violence. For instance, Otis McDonald, who is in his late 70s, lives in a high-crime neighborhood. He is a community activist involved with alternative policing strategies, and his efforts to improve his neighborhood have subjected him to violent threats from drug dealers. Colleen Lawson is a Chicago resident whose home has been targeted by burglars. In Mrs. Lawson's judgment, possessing a handgun in Chicago would decrease her chances of suffering serious injury or death should she ever be threatened again in her home. McDonald, Lawson, and other Chicago petitioners own handguns that they store outside of the city limits, but they would like to keep their handguns in their homes for protection. After our decision in Heller, the Chicago petitioners in two groups filed suit against the city in the United States District Court for the Northern District of Illinois. They sought a declaration that the handgun ban and several related Chicago ordinances violate the Second and 14th Amendments to the United States Constitution. Another action challenging the Oak Park law was filed in the same district court by the National Rifle Association and two Oak Park residents. In addition, the NRA and others filed a third action challenging the Chicago ordinances. All three cases were assigned to the same district judge. The district court rejected plaintiffs' argument that the Chicago and Oak Park laws are unconstitutional. The court noted that the Seventh Circuit had squarely upheld the constitutionality of a ban on handguns a quarter century ago, and that Heller had explicitly refrained from opining on the subject of incorporation, vel none, of the Second Amendment. The court observed that a district judge has a duty to follow established precedent in the Court of Appeals to which he or she is beholden, even though the logic of more recent case law may point in a different direction. The Seventh Circuit affirmed, relying on three 19th century cases, United States v. Cruikshank, Presser v. Illinois, and Miller v. Texas, that were decided in the wake of this court's interpretation of the Privileges or Immunities Clause of the 14th Amendment in the slaughterhouse cases. The Seventh Circuit described the rationale of those cases as defunct and recognized that they did not consider the question whether the 14th Amendment's Due Process Clause incorporates the Second Amendment right to keep and bear arms. Nevertheless, the Seventh Circuit observed that it was obligated to follow Supreme Court precedents that have direct application, and it declined to predict how the Second Amendment would fare under this court's modern selective incorporation approach. We granted certiorari. Section 2A. Petitioners argue that the Chicago and Oak Park laws violate the right to keep and bear arms for two reasons. Petitioners' primary submission is that this right is among the privileges or immunities of citizens of the United States, and that the narrow interpretation of the Privileges or Immunities Clause adopted in the slaughterhouse cases should now be rejected. As a secondary argument, petitioners contend that the 14th Amendment's Due Process Clause incorporates the Second Amendment right. Chicago and Oak Park municipal respondents maintain that a right set out in the Bill of Rights applies to the states only if that right is an indispensable attribute of any civilized legal system. If it is possible to imagine a civilized country that does not recognize the right, the municipal respondents tell us, then that right is not protected by due process. And since there are civilized countries that ban or strictly regulate the private possession of handguns, the municipal respondents maintain that due process does not preclude such measures. In light of the parties' far-reaching arguments, we begin by recounting this court's analysis over the years of the relationship between the provisions of the Bill of Rights and the states. Part 2b. The Bill of Rights, including the Second Amendment, originally applied only to the federal government. In Baron X. Rel. Tiernan v. Mayor of Baltimore, 1833, the court, in an opinion by Chief Justice Marshall, explained that this question was of great importance, but not of much difficulty. In less than 4 pages, the court firmly rejected the proposition that the first 8 amendments operate as limitations on the states, holding that they apply only to the federal government. The constitutional amendments adopted in the aftermath of the Civil War fundamentally altered our country's federal system. The provision at issue in this case, Section 1 of the 14th Amendment, provides, among other things, that a state may not abridge the privileges or immunities of citizens of the United States or deprive any person of life, liberty, or property without due process of law. 4 years after the adoption of the 14th Amendment, this court was asked to interpret the amendment's reference to the privileges or immunities of citizens of the United States. The slaughterhouse cases involved challenges to a Louisiana law permitting the creation of a state-sanctioned monopoly on the butchering of animals within the city of New Orleans. Justice Samuel Miller's opinion for the court concluded that the Privileges or Immunities Clause protects only those rights which owe their existence to the federal government, its national character, its constitution, or its laws. The court held that other fundamental rights that predated the creation of the federal government and that the state governments were created to establish and secure, were not protected by the clause. In drawing a sharp distinction between the rights of federal and state citizenship, the court relied on 2 principal arguments. First, the court emphasized that the 14th Amendment's Privileges or Immunities Clause spoke of the privileges or immunities of citizens of the United States. And the court contrasted this phrasing with the wording in the first sentence of the 14th Amendment and in the Privileges and Immunities Clause of Article 4, both of which refer to state citizenship. Second, the court stated that a contrary reading would radically change the whole theory of the relations of the state and federal governments to each other and of both these governments to the people, and the court refused to conclude that such a change had been made in the absence of language which expresses such a purpose too clearly to admit of doubt. Finding the phrase privileges or immunities of citizens of the United States lacking by this high standard, the court reasoned that the phrase must mean something more limited. Under the court's narrow reading, the Privileges or Immunities Clause protects such things as the right to come to the seat of government to assert any claim a citizen may have upon that government, to transact any business he may have with it, to seek its protection, to share its offices, to engage in administering its functions, and to become a citizen of any state of the Union by a bona fide residence therein with the same rights as other citizens of that state. Finding no constitutional protection against state intrusion of the kind envisioned by the Louisiana statute, the court upheld the statute. 4 justices dissented. Justice Field, joined by Chief Justice Chase, and Justices Swain and Bradley, criticized the majority for reducing the 14th Amendment's Privileges or Immunities Clause to a vain and idle enactment which accomplished nothing and most unnecessarily excited Congress and the people on its passage. Justice Field opined that the Privileges or Immunities Clause protects rights that are in their nature fundamental, including the right of every man to pursue his profession without the imposition of unequal or discriminatory restrictions. Justice Bradley's dissent observed that we are not bound to resort to implication to find an authoritative declaration of some of the most important privileges and immunities of citizens of the United States. It is in the Constitution itself. Justice Bradley would have construed the Privileges or Immunities Clause to include those rights enumerated in the Constitution, as well as some unenumerated rights. Justice Swain described the majority's reading of the Privileges or Immunities Clause as turning what was meant for bread into a stone. Today, many legal scholars dispute the correctness of the narrow slaughterhouse interpretation. 3 years after the decision in the slaughterhouse cases, the court decided Cruikshank, the first of the 3 19th century cases on which the Seventh Circuit relied. In that case, the court reviewed convictions stemming from the infamous Colfax Massacre in Louisiana on Easter Sunday, 1873. Dozens of blacks, many unarmed, were slaughtered by a rival band of armed white men. Cruikshank himself allegedly marched unarmed African-American prisoners through the streets and then had them summarily executed. 97 men were indicted for participating in the massacre, but only 9 went to trial. 6 of the 9 were acquitted of all charges. The remaining 3 were acquitted of murder, but convicted under the Enforcement Act of 1870 for banding and conspiring together to deprive their victims of various constitutional rights, including the right to bear arms. The court reversed all of the convictions, including those relating to the deprivation of the victim's rights to bear arms. The court wrote that the right of bearing arms for a lawful purpose is not a right granted by the Constitution, and is not in any manner dependent upon that instrument for its existence. The Second Amendment, the court continued, declares that it shall not be infringed, but this means no more than it shall not be infringed by Congress. Our later decisions in Presser v. Illinois and Miller v. Texas reaffirm that the Second Amendment applies only to the federal government. Section 2C. As previously noted, the Seventh Circuit concluded that Cruikshank, Presser, and Miller doomed petitioners' claims at the Court of Appeals level. Petitioners argue, however, that we should overrule those decisions and hold that the right to keep and bear arms is one of the privileges and immunities of citizens of the United States. In petitioners' view, the Privileges or Immunities Clause protects all of the rights set out in the Bill of Rights, as well as some others, but petitioners are unable to identify the clause's full scope. Nor is there any consensus on that question among the scholars who agree that the slaughterhouse case's interpretation is flawed. We see no need to reconsider that interpretation here. For many decades, the question of the rights protected by the 14th Amendment against state infringement has been analyzed under the Due Process Clause of that amendment and not under the Privileges or Immunities Clause. We therefore decline to disturb the slaughterhouse holding. At the same time, however, this court's decisions in Cruikshank, Presser, and Miller do not preclude us from considering whether the Due Process Clause of the 14th Amendment makes the Second Amendment right binding on the states. None of those cases engaged in the sort of 14th Amendment inquiry required by our later cases. As explained more fully below, Cruikshank, Presser, and Miller all preceded the era in which the court began the process of selective incorporation under the Due Process Clause, and we have never previously addressed the question whether the right to keep and bear arms applies to the states under that theory. Indeed, Cruikshank has not prevented us from holding that other rights that were at issue in that case are binding on the states through the Due Process Clause. In Cruikshank, the court held that the general right of the people peaceably to assemble for lawful purposes, which is protected by the First Amendment, applied only against the federal government and not against the states. Nonetheless, over 60 years later, the court held that the right of peaceful assembly was a fundamental right safeguarded by the Due Process Clause of the 14th Amendment. We follow the same path here and thus consider whether the right to keep and bear arms applies to the states under the Due Process Clause. Part 2, D1. In the late 19th century, the court began to consider whether the Due Process Clause prohibits the states from infringing rights set out in the Bill of Rights. 5 features of this approach taken during the ensuing era should be noted. First, the court viewed the due process question as entirely separate from the question whether a right was a privilege or immunity of national citizenship. Second, the court explained that the only rights protected against state infringement by the Due Process Clause were those rights of such a nature that they are included in the conception of due process of law. While it was possible that some of the personal rights safeguarded by the first 8 amendments against national action might also be safeguarded against state action, the court stated, this was not because those rights are enumerated in the first 8 amendments. the court used different formulations in describing the boundaries of due process. For example, in Twining, the court referred to immutable principles of justice which inhere in the very idea of free government, which no member of the Union may disregard. In Snyder v. Massachusetts, the court spoke of rights that are so rooted in the traditions and conscience of our people as to be ranked as fundamental. And in Palco, the court famously said that due process protects those rights that are the very essence of a scheme of ordered liberty and essential to a fair and enlightened system of justice. Third, in some cases decided during this era, the court can be seen as having asked, when inquiring into whether some particular procedural safeguard was required of a state, if a civilized system could be imagined that would not accord the particular protection. Thus, in holding that due process prohibits a state from taking private property without just compensation, the court described the right as a principle of natural equity, recognized by all temperate and civilized governments from a deep and universal sense of its justice. Similarly, the court found that due process did not provide a right against compelled incrimination, in part because this right has no place in the jurisprudence of civilized and free countries outside the domain of the common law. Fourth, the court during this era was not hesitant to hold that a right set out in the Bill of Rights failed to meet the test for inclusion within the protection of the Due Process Clause. The court found that some such rights qualified: freedom of speech and press, assistance of counsel in capital cases, freedom of assembly, free exercise of religion. But others did not, such as grand jury indictment requirement or privilege against self-incrimination. Finally, even when a right set out in the Bill of Rights was held to fall within the conception of due process, the protection or remedies afforded against state infringement sometimes differed from the protection or remedies provided against abridgment by the federal government. To give one example, in Betts, the court held that, although the Sixth Amendment required the appointment of counsel in all federal criminal cases in which the defendant was unable to retain an attorney, the Due Process Clause required appointment of counsel in state criminal proceedings only where want of counsel in the particular case resulted in a conviction lacking in fundamental fairness. Similarly, in Wolf v. Colorado, the court held that the core of the Fourth Amendment was implicit in the concept of ordered liberty and thus enforceable against the states through the Due Process Clause, but that the exclusionary rule, which applied in federal cases, did not apply to the states. Section 2D2. An alternative theory regarding the relationship between the Bill of Rights and Section 1 of the 14th Amendment was championed by Justice Black. This theory held that Section 1 of the 14th Amendment totally incorporated all of the provisions of the Bill of Rights. As Justice Black noted, the chief congressional proponents of the 14th Amendment espoused the view that the amendment made the Bill of Rights applicable to the states, and in so doing overruled this court's decision in Barron. Nonetheless, the court never has embraced Justice Black's total incorporation theory. Section 2D3. While Justice Black's theory was never adopted, the court eventually moved in that direction by initiating what has been called a process of selective incorporation. That is, the court began to hold that the Due Process Clause fully incorporates particular rights contained in the first 8 amendments. The decisions during this time abandoned 3 of the previously noted characteristics of the earlier period. The court made it clear that the governing standard is not whether any civilized system can be imagined that would not accord the particular protection. Instead, the court inquired whether a particular Bill of Rights guarantee is fundamental to our scheme of ordered liberty and system of justice. The court also shed any reluctance to hold that rights guaranteed by the Bill of Rights met the requirements for protection under the Due Process Clause. The court eventually incorporated almost all of the provisions of the Bill of Rights. Only a handful of the Bill of Rights protections remain unincorporated. Finally, the court abandoned the notion that the 14th Amendment applies to the states only a watered-down, subjective version of the individual guarantees of the Bill of Rights, stating that it would be incongruous to apply different standards depending on whether the claim was asserted in a state or federal court. Instead, the court decisively held that incorporated Bill of Rights protections are all to be enforced against the states under the 14th Amendment according to the same standards that protect those personal rights against federal encroachment. Employing this approach, the court overruled earlier decisions in which it had held that particular Bill of Rights guarantees or remedies did not apply to the states. All right, folks, that was part 1 of 2 of my reading of Justice Alito's majority opinion in McDonald v. Chicago, the seminal Second Amendment decision by the U.S. Supreme Court recognizing that the Second Amendment right as an individual right to keep and bear arms for purposes of self-defense, recognized in Heller, applies not just to the federal government, but against the states as well. Stay with me for our next show, which will be part 2 of 2 of the reading of the majority opinion of McDonald. See you then. If you like this kind of content, and I know you do, that's why you're here, you may as well consider becoming a Law of Self-Defense member. It's dirt cheap to at least try it out. You can get a 2-week trial membership for only 99 cents. Just go to lawofselfdefense.com/trial to sign up for that. In the unlikely event you don't like it and you'd like your money back, we'll give you a 200% refund. Most people, almost everyone, stays a member, and just being a standard member of Law of Self-Defense is dirt cheap. It's only about 30 cents a day, less than $10 a month. To be a member of Law of Self-Defense, get unlimited access to all our members-only content. It's the only way to have your comments and questions on live streams be addressed by me. You get a members-only podcast. Much of our content is limited, so only members can access it. Get all that and much more at lawofselfdefense.com/trial. Just try it out for 2 weeks, 99 cents, 200% money back guarantee. It's a negative risk opportunity. I hope you see you as a member real soon.